Well, hello. Oh, you watched a sad movie, Christina, or a super sad video. What did you watch? Hey, Roses Wild, Christina, and Mr. Hustleham. I don't know if my notifications are working. The last couple of videos, I've had people say that they weren't. Hey, Jessica Leasy. So hopefully that's getting sorted. And let me test and see if I can comment. Last time I could, but the time before I couldn't. I'm just gonna say, oh, not losing a child. That's the worst. Oh, I can comment. Yay. So sorry to hear that, Christina. Those things stick with you. Anything about a kid, just that's like something. That's why I would love, hey Lori, I would love to cover, hey Christy, and she loves to learn the Epstein files, but I don't think I have it in me. I might I don't know, do some kind of like posting about it, but I don't think it's something I could talk about. Because yeah, when it comes to kids, just really, really awful when you see something bad happen to them. Hey Jungle Vet, hey Pam. All right. So I don't have a fabulous thumbnail this time. I was kind of tired. I'm jet lagged. I just got back again from a trip. I've been mostly staying in Germany the last couple of months, and so my time zone and jet lag is always rough. And so I didn't sleep enough last night, but I wouldn't let myself go to bed or take a nap because I thought it's going to mess it up again tonight. So I just didn't have the creative juices, and I was so into the legal nerd stuff that I I was going for they're just so cool. I think this group of attorneys, they're amazing, they are brilliant, and they are just so cool to me. I mean, some people are like really big into celebrities, and that's just never done it for me. But hey Johnny from Chicago. I was in Chicago not long ago. We don't have a Chinese embassy, so that was the nearest to me. So I went down for that, and I had some deep dish pizza at a place called, not Giovanni, it was Giordano's, I think. And that was so good. I still have a piece left in my freezer because it was humongous. I couldn't eat one whole piece in one setting. So I packed up so much of it and then um, took it home, and I wasn't about to let it go to waste. And so it. Have you ever had, you're hungry, Christine? Have you ever had Chicago style deep dish pizza? It is amazing. It's way different than anything way up north here. Oh, okay, so you know it's did I get the name right? Giordano's? That was really, really good. I'll always go there again if I'm back in Chicago again. So, why isn't the female lawyer wearing wearing a black leather jacket? Or you mean Shapiro? I already had this picture of Shapiro. I kind of just recycled some of my old pictures. And so I had this one already for Shapiro. Yes, it's a Grease reference. And yes, Ellen is in the Pink Ladies. So the guys are dressed up like Grease. But because Shapiro was the at least, well, she's the one who signed off on it. So I believe she is the author, of course, with input from everybody else. So she's kind of on her own holding the paper. But I didn't want to not include the rest because they're just also amazing. And I'm sure they all contributed to this amazing piece of work. So I'm going to go ahead and get into it. Yeah, it's totally Grease. So we going through this motion for summary judgment, and this is picking back up part 3 going through that again and deep diving it and approaching it the way that the judge is supposed to approach it when he goes through it. And that is by looking up the cited cases, the decisions that were made, comparing them to this case, and also figuring out first. Oh, here we go. Thank you. Figuring out first the binding authority, especially if there is anything from the Supreme Court, then into their circuit, which is the Second Circuit. And if there's nothing else there, then making your own decision. It also goes hand in hand with the 56.1 statement, where Blake went through and she had to either dispute or say it's undisputed, and there were exhibits. And if she disputed it, she had to put the proof of why she was disputing it. I've got to stop looking at the chat because I really want to goof off with you guys. But I've been like, these have been so tremendously long, so I'm going to try to keep this one a little bit shorter if possible. But in the cases that we've looked at, they've done such a good job at having all of their bases covered. And if you have a case that has merit, you are able to do this. So they've covered U.S. Supreme Court. They've covered, like I said, the Second Circuit, which is their binding authority. And they've also covered both New York law and California law. If your case has merit, you are able to do that. When your case does not have merit, it gets much, much harder. Any cases you can kind of cobble together don't necessarily match your case or help you prove your case. So we've seen a lot of that with this, but when it comes to this motion for summary judgment, it is striking how many cases they're able to come up with. They are beautiful. So that's why we're going through them, because what it does is it helps us to see how strong Blake's case is and what's likely to happen when these dispositive motions, the judgment on the pleadings and the summary judgment, when those are finally decided. So one thing I noticed about the cases that we're going to go through today is that sometimes the juries can't quite come up to an understanding of the legal requirements. We covered those really, really completely in the first two about what the legal standard is. But juries don't get this long time instruction or have these thorough explanations about these legal standards. They get kind of brief instruction, and then they're just turned loose to come up with their verdict. So that's kind of troubling, but we're not doing that. We're going through exactly what the requirement is. But because they don't get a lot of explanation about these things, sometimes they make a decision that's maybe not the best when it comes to the actual legal standard. And so things often get appealed. The other situation, more often what we're going to see in these cases, is where the plaintiff themselves just cannot get past their own subjective feelings. They cannot see the situation objectively, and so they can't accept that their lawsuit does not have merit. So we're going to see that that's the main reason a lot of these end up going on and being appealed. But it's a good thing it does, because then we have a really good binding authority to go by. And then, like I said, a small number of these actually made it to the highest court. All right, let me move on. Just always want to check my notes and make sure I cover everything. So what we see in this one, we see, like I said, 2 Supreme Court cases and 2 Second Circuits. And we also see the highest court in California, all in this one little paragraph. That's what I'm saying. That when when your case is this strong, you can do this. You can find case after case after case to prove over and over again that you are right. So this is very, very strong. Now, sorry, I've got some repetitive stuff I want to cut out. Let's see. One of the cases is it was a state case that got removed to federal court. Federal court said, no, sorry, sent it back. So we're going to see all sorts of things today. But one thing I wanted to point out before we do, because I was kind of going back and forth to what is Blake's response to this stuff, or her team's response. And I noticed this just in the table of contents. There are only 4 pages. Of all of these pages, there are 60 pages here. And there are only 4 that are dedicated to defending her sexual harassment complaint. When your main claim is that you were harassed, how in the world is your defense only 4 pages? Look at that. It's so sad. And the rest of it is all about retaliation and other things, but only 4 pages. And we see Wayfarer has got just page after page after page with all of these cases to support their claim. It's so backwards. It really, really is. But I just wanted to point that out to you, to just, the judge should notice that, and hopefully he does. But we're going to start these cases now. And the first one is a Second Circuit case. It says something here: isolated acts, unless very serious, do not meet the threshold of severity or pervasiveness. This is something that we saw a lot of in the previous thing. So we're not going to spend a whole lot of time on those. We're just going to go ahead and jump in. But to try to move things along this time, I try to streamline how I set this up for you, so that it's more like a table of kind of everything that happened. So this case was appealed. Why was it appealed? Because it started off in district court. And in that district court, this is one of the cases that I mentioned where the jury kind of made a mistake, really. So they end up awarding Alfano $150,000 in emotional distress damages. Her claim was she was a corrections officer and at a prison, and she said that she experienced a hostile work environment. Now, this is something that Blake's case started off as a harassment case, and then they just kind of merged over into calling it a hostile work environment. And I talked about how I think that happened because the standards are a little easier on a hostile work environment. So we're looking at that sort of case, but the similarities here are that it was a sexual discrimination, and it was under Title VII. It was in New York. So she gets this favorable award from the jury, but she was suing the New York State Department of Correctional Services, also called DOCS. So they said, wait, this is not right. So they moved for something called a post-verdict for judgment as a matter of law. They're asking to set aside the jury's decision. They say because the jury should not have been permitted to consider certain incidents. Some of those incidents had been done away with before trial. They also say that because the remaining incidents, while they said, yes, they were sex-based, but they were insufficiently numerous and insufficiently significant. And finally, that the evidence of the emotional distress was too vague and conclusory to support the requisite finding of concrete harm. And if you remember, Blake's Blake withdrew her emotional distress claims because she was going to have to support them. One of the things that they'd asked for were medical records to say, hey, if you've got this emotional distress, you have to support it because it's a really big claim. It's not just, oh, I'm distressed by this. It's a pretty serious claim. And it comes with really big damages if you can prove it. So they're saying hers failed as well. Now, the district court, they ruled also in her favor. And they said, no, we're not granting this for you. So it was appealed and it went to the appellate court in the Second Circuit. They dismissed the claims. They said that the evidence at trial was insufficient as a matter of law to establish a hostile work environment under Title VII. So they reversed it. They affirmed the dismissal. And because she cross appealed. So it wasn't enough that she won that. They're appealing it. She's like, well, I'm appealing too. I'm saying the claims that were dismissed were wrongly dismissed, so I want those brought back. So the Second Circuit said, no, you don't get those back. This, as a matter of law, should not have been won, and so we are reversing it. So let's look at why they made the decision that they made. She had 12 claims total. 4 of those were about sexual harassment, but 8 of them turned out to be administrative and really nothing to do with sexual harassment at all. So here's the timeline. In the fall of 91, the captain, whose name was Fenton, told her that she should not eat carrots, bananas, hot dogs, or ice cream on the job because she did so in a seductive manner. Gross of him to say, absolutely. We as women, because the standard's so high about lawsuits, and most of us don't want to spend the time or the money to pursue a lawsuit in a situation where it's something like this, we need to really speak up for ourselves and just learn to say, that's gross. Stop acting like an idiot. Don't talk to me like that. But bringing these things to federal court, it's just not the way to go about it. Now, he made this statement because someone else had told him that in the lunchroom, she was eating a carrot in a seductive manner. Now, it doesn't matter if someone said that to him in an offhanded way. If it wasn't a formal complaint that he needed to sit down and talk with her about, he needed to keep his mouth shut. This was extremely inappropriate. I will definitely say that. Is it federal case worthy? No, it's not. So later, a few months later, she discovers in her workplace mailbox someone has gotten into it and arranged a carrot and 2 potatoes, suggestive of male genitalia. Then a couple months later, someone posts in the visiting room pretending to be the superintendent. I'm sure it was not the actual superintendent, saying that carrots will not be allowed in the visiting area due to Sergeant Alfano's strong liking for them. If they're diced up, it will be okay, and pretend it's signed by the superintendent. Stupid? Yes. Obnoxious? Yes. Inappropriate? Yes. Does this rise to a federal trial? No. The federal courts are so overrun. They don't just do civil cases, they do criminal cases. There are so many cases out there. When someone's tying them up with stupid stuff like this, it's not good for anyone. Then 2 years later, someone hand draws a cartoon that depicts an officer that's under her supervision making vulgar remarks and put that in her mailbox. The reason they did that is because Alfano had been investigated. She was cleared but the allegations were inappropriate physical contact with an officer on duty who she was their superior. Now, in the lawsuit, it admits that the accusations are murky, but they didn't include her kissing this officer. Now, it's said to be at a time where she was bandaging a wound of his. He was injured somehow. So I don't know if she kissed the wound. I don't know where the wound was. It did admit that the details were murky, but there was a kiss. There was also a situation where she asked him to remove something from her front pocket. I don't know if that's a shirt pocket. I don't know if that's a pants pocket. Either way, inappropriate for her as a supervisor to be instructing someone that she supervises to reach into her pockets in any location on her body. So that was the story behind the cartoon. And then the rest of them, as I said, were administrative. It was situations like she had a review. She felt like she should have gotten a higher review than what she got. There was also a situation where she had lost her temper, slammed stuff on the desk. There was other disciplinary actions. You know how you get written up? Sometimes you just get spoken to, and then other times you get actual written notice that what you did was wrong. And those kinds of things go into your human resources file. And she felt that the situation that she was disciplined, that it should not have gone in her file, but should have just been maybe something that was told to her and not put on her actual record. Then she also complained that when she wanted to get something done maintenance-wise, that she was being asked to fill out a formal work order and others were not. So I don't know if they ever got to the bottom if it was true that she was the only one being required to do it. But if something is part of your job, it doesn't matter what other people do. If it's part of your job, just do it. It's not that hard to fill out a formal work order. And if that's what you're supposed to do, it doesn't matter what anybody else is doing. Just do your job well. So this was the situation with her case. Now, looking at this, nobody touched her, well, except for the person that she instructed to. Things are obnoxious here. Things are inappropriate here. Do they rise to that level? The Second Circuit said they do not, and that the jury erred when they awarded her these damages. And so they took it back. Now, after it goes through all of that in this lawsuit, and you can look this up later when you have time, Alfano versus Costello, they went through this paragraph is pretty shocking. It goes, oh, not this one, but sorry, what this one is I don't want to spend a lot of time because we spent so much time the last couple. This is the standard for those of you who maybe didn't see the previous ones, or just a quick reminder. The standard is it has to be sufficiently severe or pervasive so as to alter the conditions of a victim's employment. And it has to be such like it would discourage someone else from complaining because, and this is for the retaliation part, they would see what happened to you and they wouldn't want it to happen to themselves. It also cannot be just subjective. It has to be something objective, which means that the average reasonable person would see this and be shocked by it. It has to be severely permeated, sufficiently continuous. It can't just be episodic, where, like her case, it was a matter of a few years, and yet there were only 4 instances. That is not sufficiently continuous. That is episodic, like Blake's complaints. Okay, so this is directly from the decision that was made by the Second Circuit. And I really think this says a lot to me about how this motion, particularly towards Blake's accusations, should come. This is what it should look like. These are the things that it should say, the cases that should be highlighted. So it said that the district court properly ruled that the 8 personnel actions could not support the claim for disparate treatment. The court erred in permitting the jury to consider them in deciding whether Alfano suffered a hostile work environment. And the remaining 4 incidents, which do have sexual overtones, are too few and far apart to support the verdict. Doesn't that sound like, I mean, it's like Blake's claims. Hers are the same, structured the same. They are too few, too far apart, not serious. It also mentions that she didn't point to any negative consequences or tangible harm. So because of this, she didn't have a demotion. She wasn't suspended. She didn't lose wages. There were no other disadvantaging results. And we've often said in the community that Blake just continued to get more and more advantages. She didn't get any disadvantages. She didn't lose anything. And so because of that, these incidents could not individually or grouped all together, they could not amount to an adverse employment action. That she failed to prove that a discriminatory motive infected those incidents. And it says again, the plaintiff must demonstrate that employees who are similarly situated in all material respects received more favorable treatment. So that's another thing when you're talking about being discriminated against because you're a woman. Blake says that the whole thing with Steve Sarowitz is that he ignored her complaint. And then they asked, well, did you ever complain to him? And she said no. There was no way that she was treated specifically for being a woman, that the men were treated better than her because they were men. So it has to fail. And then it says this is really important. The jury should not be allowed to consider the non-sexual events. All of the things that Blake mentions that are non-sexual, the jury should not be allowed to consider them as part of a course of conduct tending to show a hostile work environment. This is what the Second Circuit said. So even if they took all 12 together, which they're saying some of these 12 should have been cut, should have not been considered, but even if you take them all together, it's still insufficient, and that the district court should have granted that motion for judgment as a matter of law. They should have set aside what the jury had decided because they decided in error. Now they talk about her incidents. They say when they reviewed the incidents that fewer than half provide any support. We've seen what Blake said happened during that dance, the karaoke falling in love dance. What she said happened, she had to change her amended complaint because they released that video and we saw that it was not supported. A lot of Blake's claims end up that way. She says things, but are they well supported? For example, one of the most shocking claims she makes is about Jamie coming into her makeup trailer. We have his version of what happened. We have Blake's version of what happened. And then we have the hair and makeup ladies, 2 of them, their versions. Not a single one matches. The only one place that some match is that Blake says that he knocked and then she told him to go ahead and come in after they kind of talked through the door. But that's not what the other 2 witnesses say. Theirs are completely different. One of them has her standing in just a pair of underwear. The other one has her sitting, breastfeeding her baby. One of them says she's covering the non-feeding breast with, I forgot what she said, a little towel or washcloth. And the other one says she's putting a cloak around her. So what really happened there? when you have that many different stories. Oh, I just saw that, Terry. No notifications. I don't know why this keeps happening. Oh well. We'll get through it somehow. I appreciate those of you who showed up. I know on a Friday night when the weather's starting to get nice, there's much more interesting places to be. So thank you guys for coming here. But this is going to be one of the problems. Is these claims have to be supported. Then we have, hey Ricardo, thank you so much for being a member for 3 months. And we'll forgive you for being late. Oh, you did, Lori? Okay, good. Somebody got him. Hey, Michelle. Hey, just snooping. All right, I'm not going to get too distracted by the comments. I know it's been a while, so whenever I've been away for a while, I just want to chat with you guys. But these things will go so long if I do that. So I'll try to do that, save that for the end. Okay, and then where'd I leave off? This point, because one of the claims, when she dialed everything down to a hostile work environment, she said that if she said something, that he would go off in a huff. Oh my goodness. Not someone being in a huff. Considering what she was putting him through, it's amazing that the guy didn't just absolutely lose it, is what I've got to say. But yeah, that is, believe it or not, one of the accusations about a hostile work environment is that Justin would get in a huff and walk off. Better walk off than to stay there and say something in anger or lose your temper in front of everybody, right? But anyway, it says everyone can be characterized by sex, race, ethnicity, or real or perceived disability. And many bosses are harsh, unjust, and rude. It is therefore important in hostile work environment cases to exclude from consideration personnel decisions that lack a linkage or correlation to the claimed ground of discrimination. So what does that mean? If the judge takes it seriously that he walked away in a huff, can he link it to discrimination? Can he say that Justin's huffs were because she was a woman? I think not. So even if you can say, oh, well, him being in a huff was hostile, which is absolutely ridiculous, you still have to link it to this discrimination, which you can't do. And here is something really, really important. Otherwise, the federal courts will become a court of personnel appeals. And that is the truth. If everybody who got their feelings hurt by a boss being harsh, unjust, or rude took it to a federal court, can you imagine? Can you imagine what the courts would be like? They're already overrun. It's just silly. And it goes on to say the court's role is to prevent unlawful hiring practices. So they're there for the real discrimination. Were you passed by for this job because you're a woman? Were you passed by for this job or this promotion because of your skin color? Were you mistreated or treated differently than the men or differently than people of another race? That's what this is all about. That's what they're here for, not because somebody got into a huff. And it goes on, not to act as a super personnel department that second guesses employers' business judgments. And we talked about that in the last one where we covered this motion, that they're not what was the expression they used? I can't remember, but basically saying they're not like policing the workplace. That's not their job. It goes on, federal courts are not in the business of judging whether employment decisions are prudent or fair. Instead, Our sole concern is whether unlawful discriminatory animus motivates a challenged employment decision. So there it is. This, oh, that's sweet, Aunt Clara. I took a peek. This makes it so clear. These are not the types of cases that the EEOC and that Title VII and that departments of civil rights are set up for. They're not here to make sure that workplaces are prudent or fair or that bosses don't get in bad moods. They're just there to protect against real discrimination. Now, I noticed a side note in this case. The time between her filing her EEOC complaint, look at it, it was February 7th of 1992. She got her right to sue letter in August of 1994. Over 2 years later, like 2.5 years later, she gets her right to sue letter. Why am I talking about this? Because Blake got hers immediately. Is that a big deal? Just last summer, and I talked about this before when I was covering something, I can't remember what issue it was, but there was a case that was in the Eastern District of New York, so a sister to the Southern District. And this was about an EEOC right to sue letter. What was the issue? They said, now this wasn't a sexual harassment, it was discrimination. It was more of a disability situation. And it involved her medical, her FMLA, that kind of stuff. And I think she ended up fired, if I'm not mistaken. But it took the EEOC that long to issue her a right to sue letter. And the other one, but this one, what does it say? A mere, oh, come on, stop. This thing is in my way. Sorry. I'm trying to close that thing down so I can read it, but I can't read it. What does it say? 57? Is it 57 days? So 57 days later, and this goes to court. Why? It says that she failed to satisfy the statutory precondition that her charge of discrimination be pending with the EEOC for the required 180-day period. And so the court decided what? Her letter is defective because that is the statute. The EEOC has a requirement of a 180-day period. If it doesn't do that, it is considered defective. Now, what had happened is they just started willy-nilly handing out these right to sue letters without investigating, without waiting the time out. But that's not a good idea, because one of the things that the EEOC can accomplish, they are there to investigate. So if they investigate, they can do away with a lot of these cases before they come in and tie up the courts. But if they're just like, oh, we're behind here, you can sue, that's not working out very well. And that puts a heavy burden on the courts. And so they said, they made this decision, okay, go back to the EEOC. They remanded her back. They're like, you have no lawsuit. Your letter is defective. Back to the EEOC to do this properly. And so it shows here the statute where this comes from, directly from the government, the federal government, and it says that that's where it says these 180 days. Now, another thing I want to point out, they quoted from a certain case. And so we're going to talk about that case because this is a situation where something big happened. So we had a standard that had been set forth by the U.S. Supreme Court that was set forth in 1984. And because it became a standard, a lot of times these standards are given like their own title instead of just quoting the case. It becomes a title, like this one was called Chevron deference. And what this was a doctrine that was set forth, like I said, in 1984, where courts deferred to a federal agency's reasonable interpretation of an ambiguous statute that the agency administers. So under this decision, for example, the EEOC, they were okay to say, well, this is our interpretation. We don't have time. We're backed up. We're not going to get to this in 180 days. So here's your right to sue. That's how it was. But a new case came along in 2024 that overturned it. This is kind of a big deal when these things get overturned because they've been long-standing standards. They don't happen very often, and this is one of those cases. So the Chevron deference lasted from 84 to 24, 40 years, and what it was this two-step test. So if the statute from Congress was very clear, you followed the statute. If there was something ambiguous about it, if it could be interpreted in different ways, if it was not easy to understand, then the courts would leave it up to the agency to interpret it how they chose to. So agencies like the EEOC won disputes over statutory interpretation. But the new standard in the Supreme Court is Loper-Bright, where they said courts no longer defer automatically to agencies, but instead, judges must use their own interpretation of the law, so they independently interpret federal statutes rather than automatic deferral to federal agencies' interpretations, because better a judge, right? We don't know who in these agencies were making the decisions, but coming from a judge, they've got years of experience. They know the law inside and out, or should. And so it made more sense to put this in the court's hands and not the agency itself. Agencies get no special advantage simply because they administer the statute. And so in this case that gets over, or that deals with this EEOC, that's what they quoted as saying, no, this is wrong, follow the statute, and this is the way it's going to be. So that happened last year, and it tells us that, and I'm surprised that the Wayfarer team did not mention that under these new rules, that it makes Blake's letter look like it is defective, and therefore should be remanded back to the EEOC. Then again, I don't know the ins and outs of that, and if there was some reason why they couldn't just go to that and say that. So moving on to the next case, that was Alfano versus Costello, and now we're in back to California, their Supreme Court. The sporadic use of abusive language, gender-related jokes, and occasional teasing are not actionable harassment under federal or California law. The reason they're putting this is because Blake, even though she's in a federal court in New York, she has asked to apply New York law to her claim. And that gets discussed a little bit later in the motion for summary judgment. So if you're wondering about that, we'll get to that later. So this is Ailman versus Airgas USA. And this case was not a sexual harassment case. This was a race discrimination case, but these kinds of things do fall under a lot of the same standards. This had other issues. This had fraudulent joinder. If you're from the Murdaugh crew, you probably recognize that. That came up with Buster Murdaugh's case, where he was suing, it's still going on. He's suing Netflix. He's suing Warner Brothers a big newspaper company, some local reporter in South Carolina where he resides, but he wanted the case to be kept in South Carolina. So one of the accusations was that this reporter and this South Carolina newspaper were added fraudulently as a fraudulent joinder. They were added to the case just to keep it in that specific jurisdiction because he wanted it in his home jurisdiction where he felt he would more likely get a decision in his favor. It did get removed to federal court, but he fought and fought and got part of it. It was the weirdest thing. The case got split where part of it stayed in federal court and part of it went back to Hampton. Very, very strange. But this was that situation too. They call it fraudulent joinder, and they say the defendants are sham defendants. They're put in there just for a specific jurisdiction so you can court shop. So this is the one that was remanded back, and those have nothing to do with Blake's case, but what it has to do with is we have this long list of his claims. So there was a failure to provide meal breaks, rest breaks, wages weren't paid correctly, overtime wasn't paid, there were not accurate wage statements, and he says, like, his main claim is race discrimination. He says he was retaliated against. There was a failure to prevent discrimination and retaliation in violation of FEHA. There was a hostile work environment and a wrongful termination. So he's got a long list of what sounds like some really, really serious accusations. But even at that, the court finds that there is no recovery for harassment that is occasional, isolated, sporadic, or trivial. So these kind of claims also, it can't be, oh, this happened then and that happened then and this long period of time happened in between. It has to be pervasive. It has to keep happening, and has to have a repeated routine. As they say here, sporadic use of abusive language, gender-related jokes, even though those things are inappropriate, occasional teasing, they are not actionable because they are sporadic. There just isn't enough time to handle all of these cases. People suck. We're terrible to each other. We have a bad day, we take it out on someone. We have situations stressing us out, we take it out on someone. Some people just never grew up and they're inappropriate or vulgar and treat people in awful ways. But not everything rises to a lawsuit, and that's what they're trying to say. So they do mention, and we are going to discuss this a little bit more in some other cases, there are situations where isolated incidents can support a harassment claim, but they have to be severe and they have to be extreme. Things like physical violence or the threat of physical violence. Is this the one that mentions, let's see. No, but I think I forgot to clip it. When I was reading through these, there was a situation, it was firefighters, and there was a woman who was, she made some similar claims about the hostile work environment, and she won her case because each case is weighed individually by its own individual circumstances. As a firefighter, you have to be able to rely on each other. You have to be confident that your team is looking out for you because your lives, you're risking your lives. So you have to work together, you have to help each other. And if you're going into a situation where your life is in danger, you want to know that you can trust the people, that they have your best interest at heart going into these situations. And so her claim was different because it did come down to a threat. a situation where they may not rescue her. They may choose to rescue someone else instead, or not feel she's worth risking their own lives for. You can't have that situation. That's an actual life-threatening situation. So, another thing that it mentions is that it doesn't include conduct that is necessary for management of the employer's business or performance of the supervisory employee's job. So, necessary actions like the job itself, project assignments. Now, this comes down to, in Blake's situation, one of her big things where she says, oh, he said these gross things to me. He talked about his personal private sex life with his wife. What do we learn about that? It was under a situation where he had come to discuss the sex scenes, the writing of and planning for the sex scenes. He had invited her to come when he met with the intimacy coordinator, and they could have three professionals or supposed professionals met together and gone over this. But she said, nah, you go ahead. She didn't join. Then, instead of coming to work, as we know, she didn't like to come to work. She kept beckoning him to her home. He had to come to her home by himself and relay the conversation that had taken place between him and his intimacy coordinator. And unfortunately, she wasn't grown up enough to have this kind of conversation. And she saw these things as him just trying to talk dirty to her, which was absolutely ridiculous. We saw the notes, we saw where the things that he discussed, where they came from. They came from that conversation with the intimacy coordinator who had steered him towards a women's movement. I've talked about this a couple of times already, where they were trying to change the way intimate scenes are portrayed in TV, on TV and in movies and that's where this expression female gaze came from. So he is having to relay this stuff to her, and she's like, oh, you're talking dirty to me. It's so stupid. But that was, in fact, an assignment. And he had been told by Ange from Sony to turn up the heat, that it wasn't spicy enough, it wasn't sexy enough, it wasn't grown up enough. We saw the actual conversations between Ange to Justin, and we saw his notes from the meeting with the IC. Everyone else was able to handle those conversations, but for some reason, yes, Gloria, Blake is too immature. When he took that information to her, she couldn't handle it and thought that he was just talking dirty to her. But those things, it says it does not include these things. It does not come within the meaning of harassment. So that one fails too. Next, now with national, we're not going to deep dive this one because it is a discrimination case. It is not sexual harassment, and it focuses mostly on timings of filings. But what they've done is they've pulled key language that was put in the decision that can apply to this case as well, because this was also another U.S. Supreme Court decision. So we're just going to read the quote here. Courts consider the totality of circumstances, the frequency of the discriminatory conduct, its severity, whether it's physically threatening or humiliating, or a mere offensive utterance. Did it offend you? We understand you're offended, but that doesn't rise to the standard. And whether it unreasonably interferes with an employee's work performance. And keep in mind, you can't just say it interfered with my work performance. You have to be able to support that claim. Did you end up going to therapy to cope with your job? Did you end up being medicated? Did you have to go to did you talk to your friends? Did you become ill? Did you lose weight? Did you gain weight? Did you lose sleep? What happened that made your work performance, that unreasonably interfered with your work performance? And that is the important part about that case. So moving on to Kaytor versus Electric Boat Corporation. This is also decided in the Second Circuit. And relating to that, it says it is not enough for Lively to say that she personally found something Baldoni or Heath did objectionable. Because, as we learned before, an objective and a subjective standard must be met to sustain a claim. And that's the purpose for them putting this case in here. So what is this case about? In this case, the district court granted summary judgment. They dismissed the complaint and they concluded that Kaytor failed to adduce evidence that would permit inferences that the incidents of which she complained were sufficiently pervasive or severe to create a hostile work environment, were gender-related, or were retaliation for her protests against sexual harassment. So this one is probably more like Blake's case than the others. She appealed it and said that summary judgment was inappropriate, saying that there were genuine issues of material fact to be tried as to each of her claims. Personally, I think, and this is just my own opinion, just what I think is going to happen, I think there will be some situations that are not don't actually need to be tried, that the judge is going to say need to be tried. I think some will be dismissed as they should be, but I think anything that does get dismissed, I think Blake is going to probably appeal, especially if he gets rid of some of her biggest ones. And so we're going to find ourselves in this exact situation that she's not going to be able to accept that it's correct. Now, the Second Circuit agreed that summary judgment was inappropriate with respect to the claims of hostile work environment and with respect to one aspect of her claims of retaliation. We're going to talk about why in a moment. And so they remanded for further proceedings with respect to those claims. They said, basically, when you remand, they tell you, they spell the law out for you and say, try again. Now, there were other claims that they did say, yeah, those need to be dismissed. But what was the situation here going on? This was actually investigated. So there was an investigation report. There was also deposition of the manager who she accused of this situation. So she worked in this company for many years, and the first several years, there were no incidents. But then McCarthy, who had previously been just fine, started having personal problems. He was going through a divorce. When he went through this, they said he had a change of character. Instead of seeking help, he put his pain on other people, specifically her. He started to make inappropriate comments to her. He started to engage in sexually suggestive behavior. And it was all targeted to this one woman. It wasn't happening to other people. He did make fun of women, especially their weight, but not directly. And he made comments about their bodies. Now, when it came to her, he was complimenting her on her clothing, talking about how good she looked for a woman of her age. They were not in of themselves offensive at first, but she noticed he kept staring at her body and leering at her. And then it escalated. He came into her office. He complimented her on some of her scarves that were on the desk. He picked them up. He brought them up to his nose. He sniffs them and says, they smell like you. Then he approached her and smelled her hair. That's creepy. I think I would throw hands. But in that situation, she just kind of froze, and she just kept her back to him and just like started furiously typing and ignoring him until he finally left her office. So in her opinion, what she thought was happening is that he was trying to, because he was now single, going through a divorce, he was trying to attempt a relationship with her, but she was not interested. And when it became clear to him that she was not interested, he started to make these off-colored comments, and he started to get aggressive, which we're going to see. One day, he just shouted out that it wasn't even part of the conversation. He just shouts out for everybody, no sniffers in the chat, right? I was sniffed on a bus before. It was very, very creepy. I did not like it, and I still remember how it felt. But he just screams out to the office that she has a flat bottom. And it had nothing to do with the conversation. It was completely unprovoked. It was just a very, very strange thing to do. And now we get to the heart of why this case is different from the others, and why they said no, summary judgment should not have been granted. He started to threaten her with physical harm. He started to say that he wished that she was dead. He said things like, "I want to see you in your coffin." Now that's creepy. That's exactly what we talked about a moment ago about it being severe physical harm or threats of physical harm. Somebody saying they want you dead and they want to see you in the coffin, that is creepy, horrifying. I don't think I could go back to work. I think I would probably have to move if somebody said that, because the way women turn up these days is it's awful, Christina. So on at least 6 occasions, he said that he wanted to choke her. This guy's often saying he wants her dead, wants to see her in a coffin. 6 times he says he wants to choke her. That's severe. That is life-threatening. That is horrifying. Okay, so the coworkers now are hearing these comments. And some of them are saying, "Do you realize what he's saying?" Because she's trying to like not overreact. She's trying to just be like, and a lot of us tend to think we don't take these things seriously when we should. And so this is what she's doing. And they're like, "Sharon, something's wrong here." And she continued to brush it off, but she was getting nervous because he just didn't stop saying it. And one time he called her into his office and said, out of the blue, "I wish you were retired." And she asked why. And he said, "So I could come to your home and choke you." I mean, wouldn't you want to just call the police? Like, this is awful. And there was another time that she had to inform him, because he was a supervisor, that she needed to leave the office. Now, he overheard her talking to some of the other women in the office. As women, sometimes we do. We say things to our female coworkers that we're friendly with. That what she was doing was she had her annual checkup with her gynecologist. He overheard. So as she's leaving, he yells, "You're going where every man wants to be." And another time, someone asked where she was, and he said, "Oh, she's spreading her legs for her doctor," which is so creepy, so inappropriate, which those things by themselves wouldn't rise to the thing, but combined with everything else, creepy. And a lot of times choking is sexual in nature. Like, it often goes hand in hand with assault. And so the fact that that's what he keeps bringing up is a little terrifying, and goes hand in hand with the other sexual things and the sniffs and that kind of stuff. So she tells him that if he doesn't stop, that she's going to report him. She's had it with ignoring it. She's had it with brushing it off. And his reaction is what you would expect from this kind of a creep. He gets a horrid look on his face and he says, "I'll kill you." And she says she's scared to death by that response. She goes back to her office and she decides, oh boy, I better never do that. So now she's discouraged from reporting it. Then comes Administrative Assistant Day. That comes around every year. And previous years, and remember, she's worked here for years, and he was normal in the beginning. Previous years, yes, angry, rejected male. Exactly, Jungle Vet Jill. So previously, he had bought her beautiful flowers. This year, he buys her a plant, but not just any plant, but a withered and dying pussy willow plant. And he handwrites a card that mentions something about it bringing her pleasure. And so now people, they're hearing this, they're seeing this stuff. And so this is becoming big conversations throughout the whole office. And so she decides she can't take it anymore. She's afraid. She never knows what he's going to do or say. And now she's being talked about by everybody. She's starting to feel ostracized. And so she's like, yes, I'm scared, but I have to do something. And so she complains. And what happens? They move her, not him. They move her. And now they investigate and people corroborate her story, but she's the one that gets relocated. He keeps his job. He stays a supervisor. She gets moved to working for somebody who works under him. And so they're afraid to make him angry. So they're not nice to her. She gets relocated. She loses her nice office. She loses the job position that she had and the tasks that she loved doing. And now she's sitting in an office that's literally got peeling lead paint that's falling on her desk. Her boss is constantly yelling at her loud enough for all to hear. McCarthy's his boss. Maybe he wants to keep McCarthy happy. Maybe he's been instructed to do this by McCarthy. So he does it loud enough for McCarthy to see that he's yelling at her. Her schedule gets changed. Her assignments get changed. And she ultimately gets fired. This is retaliation. This is what retaliation looks like. Her job was changed. And not in a good way. And then she lost her job. This is exactly what retaliation looks like. And it was even so bad that when there's this appeal, the EEOC actually files an amicus brief for her. And they say that the threats to kill, they're severe enough. They meet the standard. And also, there is temporal proximity, which is as soon as she complained, all of this about her job changed. She lost her office. She's in an awful office with peeling lead paint, a health hazard. She's getting screamed at. Her schedule gets messed with, and ultimately she gets fired. So, whereas Blake's, what she claims to be retaliation that does not rise up to the level of retaliation. It's an invisible campaign because it never happened. It does not exist. It exists only in her mind. And even if it were real, there was not temporal proximity. It was too far apart. But this case was not. And so this is what it takes when the court says pervasive, severe, and temporal proximity. This is what they're talking about. This is really, really awful. I feel so bad for this woman and what else she went through. I can't imagine what it felt like. Just day in and day out, having to put up with this constantly. So now we go back to the motion. And where are we here? We're going to talk about the language. Now, this isn't exactly directly saying unclean hands. They have used that in their defenses, but it in a roundabout way, it kind of is because it's talking about Blake's own language, things that she herself said. You can't make a literal federal case about something that you have done or are doing yourself. And so this goes into that, talking about, first of all, saying that these few offensive utterances that she claims happened do not satisfy the standards, but also they bring out how she herself used the word sexy to refer to how female actors appeared in their assigned. No, sorry. Her claim is that Justin twice used the word sexy to refer to how female actors appeared in their assigned wardrobe. And they say that this was a sexually charged nature of scenes in the film. They they were supposed to, and they knew they were supposed to appear sexy in the movie. This is something that Blake herself acknowledged. She talked about on multiple occasions. And so they come to this 56.1 statement. And this, like I said, this goes back to why things were unsealed. This is the actual evidence that they present together with this motion for summary judgment to say, look, here's the proof, judge. This is why you must decide this way. So these first instances are Blake's own use of the term sexy, and also the fact that Ange from Sony was directing them to turn up the heat. And so let's take a look at those exhibits. So the first one it mentions is 180. This, we know, we've heard this so many times. A lot of these we're already really familiar with. But she preferred the beanie, and we've all laughed at her for this because it's just so stupid. She preferred the beanie because it made it sexier, but she expanded on that, saying that it's hot. These are saying something is hot and saying something is sexy are two of her biggest complaints against Justin. And here she is saying them to who? To Justin, and also to Ange from Sony. And look, undisputed. So I don't know if you've looked over this statement. I love this statement. It spells everything out, everything about the case. It puts the evidence there. And like I said, this is why it was unsealed. And then she has to respond. And if she can't defend her response, she has to say undisputed. Like this case, they can't say she didn't say it because she did. And here is where she said it. So on the top, it's her conversation with Justin. So she's suing Justin for saying her clothes look sexy, but here she is describing her clothes. Well, this stupid beanie that's not sexy as sexy, but she expands on that. She talks about with the crop top, the rest of the skin, and she says, it's a girl I would check out walking down the street, and repeats, oh no, she doesn't repeat it. That's just Justin responding to that. Now we go down to Ange's text, her text to Ange, I mean, and she repeats the same part. I'll probably just copy and paste. And as we know, Sony was already worried about the wardrobe. So I think this, in addition to proving the point, I think this one was a little bit funny because after she says that to her, Ange is like, well, do we have time to shoot one clean just in case? Like she doesn't, maybe wants her to shoot one without the beanie because she's a little bit worried about the wardrobe situation. And of course, Blake does not like to be disagreed with. She says, I think this is hot. And, but look at me. So anyway, these are just the evidence for the judge to consider that she invited this kind of conversation by using it. Then we have this ridiculous video of And as they say it, and you'll see it, it's Blake explaining to a group of male crew members, she's surrounded by men, why her boots are so sexy because they are just bone hitting wood. Now, you know, these men couldn't care less about her shoes. I want you to look at everyone's reaction. I mean, they know they've got to try to make this woman happy, but look at the faces. Everybody looks hot. Everybody looks tired. She's asking them to move this chair over closer to her. She's going to sit in it. But one of the things about it that gets me is this woman who is constantly accusing people of looking at her boobs is sitting on the floor and her boobs are spilling out over the top of her dress. Now, I'm not slut shaming her. Dress how you want to dress. Put them out there, Blake. But then don't keep accusing people of looking at them. When you put things on display, so apparently, I'm sorry, isn't that the point of you putting them on display, is for them to be noticed? I mean, put it out there if that's what you like. But then don't sue people because you think that they looked at your boobs when they complimented your dress. You know, I'm not saying a woman deserves to be sexually harassed because of the way they dress. That's not what I'm saying. But if you're so prudish about things, then I I don't know. Do you guys know what I'm trying to say? Before I got accused by someone of basically saying that, "Oh, you deserve to be sexually harassed." She was not sexually harassed, first of all. But like if you're so sensitive and you're so prudish, why do you put it out there? You know? And then imagine that everybody's looking, even when they're not. All right, but let's take a look at this video. And I want you to look at everybody's faces, what they look like. They're just like, "Oh, here she goes again." And listen to what she's saying to a bunch of men. There was one woman and she just walks away. You could tell these people have just had it. But look at what she says to a group of men as she sits on the floor. Can I just put a chair right there? Just the closest distance. I know it seems so ridiculous. I don't think it seems that ridiculous.
It does not.
The problem, the reason they're so sexy is because it's just like naked foot like Cinderella, but there's no platform. So if your phone is hitting wood, it is. It's actually really cool. And I did it for 12 hours.
Now tell me, any of those men cared about her stupid boots? That, according to the book, is nothing like the way Lily dressed or carried herself. She wasn't into that kind of stuff. She was very laid back. And Blake decides to bring these shoes that nobody cares about. She wants the dance scene where she claims that he's harassing her. She has it, the shooting is done and she has them come back and repeat and do more shooting because she wants these boots filmed. It's so ridiculous. Nobody cares about these boots. But the way she described them, naked foot, bone hitting wood, they're sexy. And then gonna bring this man to federal court because she says he said her onesie was sexy. So speaking of which, we're going to look at that one next. And this one's a little bit longer, but I'm probably going to stop it in a couple of places because I can't remember exactly all the points I want to mention. But there's several things. If you've watched this a few times to like really absorb what's happening, there's just so much here.
And then he was sitting here on the stool.
Okay. That's where Justin mouthed the words, "It's so hot." That's what she claims that he's talking to her about when she takes off her coat and her zipper's unzipped, too low. Well, nobody told you to unzip your onesie. You chose to do it. Why are you fussing about it like somebody's making you do it? That was your option. That was your choice. Now, you saw his face. I'm going to play that part again. You saw his face, okay? This man, let's talk about neurodivergence, because I am. And Justin has admitted that he is as well. So I'm not spilling health secrets. This situation in this room would have me literally crying. It's far too many people. Everybody's talking about something else. So there's like a million different conversations happening. People are trying to give direction, but the group as a whole is not paying attention. That's another thing that drives me crazy. It looks hot. They're wearing fleece onesies, which it's just all nightmare fuel to a neurodivergent. It's probably like the end of the day where he's just had it. This woman has stressed him out. Every single bit of his movie, she has changed. She changes it every single day. And he's probably just all he can do to just cope with everything that's happening. There are lights in different places. There are just so many things here that are a neurodivergent nightmare. And I can't believe he's keeping it together. And he's having to deal with this woman who, in the book, in this scene, yes, overstimulation. In this scene, the whole point is they are supposed to be wearing onesies. She's got this big, ridiculous camo coat over her onesie. And he's like, I am your director. Take the coat off. This scene, nobody else here is wearing a coat. We're all in onesies. You're supposed to be in a onesie. Do what you're supposed to do. So, but he's trying to be nice and coax her out of this coat. Now, they word it in her document as if he is pressuring her. This does not look like pressure. And she's still wearing the coat when he says it's so hot. And like he said previously, he's talking about the temperature. All of these people are in there. There is no AC. It's a nightmare. It's hot. But watch his face again.
And then he was sitting here on the stool. Thank you so much.
Did you see the eyes? Like, he's almost looking at her like, are you crazy, lady? Like, what is wrong with you? And look at his face right now. He's not turned on. He's not ogling her, leering at her. He's like, you crazy lady, will you do what you're supposed to do? He's like, you should take it off. I mean, look at his face. He's not impressed with her boobs right now. That's the last thing on his mind. He's like, get it off. You're making me hot. Just seeing you in it. Like, look, he's unzipped his onesie off and just in his t-shirt because they're not filming at the moment. And he's so hot. And just seeing her in that coat is he could probably feel like he's in that coat. All right. And then he listens to her. And he's like, yeah, are you comfortable? Because he can't believe she's being like this.
Ready, everybody?
But look at the face. Is he ogling her? Yes, it's a negotiation. It's like a hostage negotiation.
Really should go, please.
He's beside himself. Do you see the gaping mouth? Like,
So again, who's gonna watch everything here? A wall comes in, right? So please make sure that nobody's standing right.
and he's still like, come on, because we can't really hear what she's saying, but she's not cooperating, and he's just like, he's disgusted with her. Yeah, he's irritated. It's bothering him, and I know that feeling very, very well.
Here, please. Okay. All right. We should go. Ready?
Now, another girl is like, she gets in on it because she's probably like, what are you doing, Blake? This is crazy. Look at his face. He's like, he can't even fathom it. And so she's trying to be sweet about it.
Somebody locked it up.
And now what happens? He notices something's in her teeth. This man is not looking at her boobs. All right. And I think that this is at the heart of it, that she gets embarrassed because she's got something in her teeth. She's embarrassed and she goes and she like picks her teeth for forever. And then they add in their comments that Jenny makes a comment to say, oh, we don't speak on each other's bodies. Because he, at this point, he does say that. He says, you know, oh, it's sexy. Oh, it's hot. No, the hot, he says, is because of the temperature. But so he's trying to coax her out of it by saying, oh, it's sexy. All right. And so she corrects him. She's like, well, we don't comment on this kind of stuff. We're not going to do that. And then they say, he says this about, oh, well, I missed the meeting. He's just aggravated. It's a wonder that's all he said. And you know what? If somebody said something to me like that, like insinuating that that's what I was doing, I would be mad too. And I would defend myself. I would say something smart alecky too. You know, don't accuse me of that. You know, I would be offended too. But look at the rest. This camera keeps rolling. Watch them. I made some cuts here because I didn't want to play it for as long as it is. But I want you guys to watch like how the body language goes between the three of them after this all happens.
Can we get a
Toothpick, please. Viv, do you have a toothpick?
Yeah, right here.
Thank you.
So that little like shrug must be the part that Jenny Slate says. She tells him that, and he's like, oh, I guess I like shrugs and says, oh, I guess I missed the meeting. Did you see that? It was not a big deal, and he does not storm off.
Whatever you do, you're always pantomime talking to one another. You're always saying something, right? About the game.
Yeah, I'm going over there. Like plus
All right, we should go.
Oh, really?
Looks it good for you?
Oh, so you put you in the freaking in the boys' room?
Yeah. It means always like not a good team.
Yeah.
Nothing else is important about what I said. We can't really do much. But this is, I just left her. She's really worried about something being in her.
All right, thank you.
But the three of them are standing there in conversation.
I'm good.
Ready? Here we go. Ready,
Laughing.
everyone. High energy. Have fun. That's the most important thing, everybody. You're in a bar. Have fun, right?
Two patients.
All right.
Now she's
Thank you, everyone. Sophia,
directing
you
people
here?
to smiling. The three of them are in a conversation.
All right. Thanks, everyone. Yeah, we'll make sure that we last look after every take. It's very schmetty in here.
See what the AD just said? She said, make sure we do something about the take. She doesn't want to have to prolong it. She goes, it's very sweaty in here because it's very hot. See, he's standing right next to Blake. Jen's smiling at him. They're in conversation. He touches her. That's fine.
But I think those are the salts. Right.
Yes, 601 is the
So do that, right? So keep it going.
Okay. All right. Did you guys, I mean, am I seeing something differently than everybody else? I saw someone said, oh, she's upset. She's embarrassed about the toothpick. I think so too. I think that's what made her feel really uncomfortable. And she remembered that feeling of uncomfortableness and blew it up into something bigger. The other situations where she got so angry is when he didn't listen to her. He didn't take her suggestion. That always made her really upset. So what is this feel? I'm going to have to look into that. When with the days that I'm putting an episode together, I don't look at anything else. So it looks like I missed Ryan being hit with a big lawsuit. Good. Oh, poor Ryan. But like I was saying the other day, poor Ryan. I can't wait to look at that. Cassidy, you should watch the video of Kathy Bates being told she thanked her mother at the Oscars. It's devastating, but it shows how gaslighting can create false memories. Makes me think of it can, especially people who have. It was a hostile workplace. People who are have high empathy and can really feel for another person. It's much easier to victimize people like that. Unfortunately. And let's see, how did we get to here? Where's my sorry, let me catch up to. Okay, this is another one that is mentioned. This is mentioned specifically about the bottom, but I noticed something about it that bothered me new. Something I had, because I was so focused on the bottom and was so shocked by the bottom that I kind of ignored the top. So this is Blake talking to Brandon. And there's an audio recording, and unfortunately we don't have that. But afterwards, he responds to her and he says, I don't know what it is that he got in there, but he's complaining about ADR. Had to look that up. It's like after something's already been filmed and the actors have to come back and re-record audio for some reason or other. And he says he hates it. And he's supposed to be doing that in the studio in a few weeks. And Blake says, yeah, to be decided on that. And he likes that. And he says, I thought so. So here's this guy. He should be grateful that he's on a TV show. All right. A lot of actors never make it, never get put on a regular TV show. They're just like an extra on one episode, something like that. But he's not grateful. He's complaining. And she's like, oh, well, let me take care of that for you. And his response, I thought so. To me, that really, really hit me, because I was like, he knows, he's sitting there expecting that she's going to do some kind of favor for him and get him out of that. Now, most people, they make it to a TV show. They're so grateful. They don't want to lose it. They want to be good. And they're like, oh, I can't do that. I've got my job to do. But to me, it feels like he's being promised something. So he's not worried about this little dumb TV job he's got. To me, it's like he's speaking with all the security of not worrying about his job. Yeah, Yellowstone, I think is what he's in. Because he's like, oh, okay. Yeah, I thought you were going to get me out of that. And then she does like zip lip. And right away, what does he say? Thank you. So that tells me they've been having conversations about what she's going to do for him. Do you know what I mean? And then she outright says, You'll be busy in Dallas instead. What is she talking about? Book Bonanza, of course. So if you look at the date of these messages, this is in May 24th. So it's pretty close to the end of May. When does Book Bonanza take place? A couple of weeks later, just like he said. Well, I'm due in a couple weeks to do this. And she's like, oh, I'll take care of that for you. And she flies him. He was not supposed to be there. Justin was supposed to be there. But Blake flies her favorites out to, yeah, I keep hearing about that. That's so gross that he was promised Batman. But there he shows up, and he's considered to be one of the principals from the movie, which it just like really irked me because he didn't even have that big of a part in the movie as far as like time wise, like to be called a principal, because most of the scenes with him was young Atlas. You know, it was divided between the two of them, and the main characters were her and Ryle, played by Justin. And then we get to the disgusting comment that's the point of this, is what she says to him, which is so inappropriate. She says, I'm becoming pimp adjacent. We all know what a pimp does. Put on a short little skirt and get on that corner. We also all know what on that corner means. And then she can't even spell his name. She calls him Skelnar. And then she adds, because I'm not selling this movie on him. And this says so much to me too. Not only is she speaking vulgar like this for no reason. They're not writing a script. This is the way she's having conversations with this man. This is the way she speaks to people. But Justin saying her clothes are sexy is a federal case. And then we see the power that she knows good and well that she has. Because I'm not selling this movie on him. She's talking like this is her movie. Like this isn't Justin's movie that he spent 5 years on. She is calling the shots and deciding how to sell this movie. And she's not selling it on Justin, the actual owner of the movie. So this one little message to me has so much going on. I think it shows that she's offering favors for these people and doing favors for these people to get them on her team. And Brandon's not worried about losing his TV job. And she talks filthy as a married woman who pretends to be a prude to this young man. There's just so much going on. And she shows her power. What else do they mention? They talk about her rewrites of things. So the karaoke scene. And she talks about, she knows the scene is supposed to be sexy. And she says, karaoke's not sexy. So I've got to revise this to make it sexy. And also this scene that she revises, where she ends up after the birthday party, she ends up in his apartment. She changes that to where she ends up in his clothes and he ends up naked. And other things that she says, these are all very sexual, and they're things that she herself changed. Now she's accused him of rewriting things and changing things, and it's not the script she agreed to when she agreed to do the movie. And they're like, but this is what she was doing. So how can he be sued for it? And then here's the actual email where she says it. And it's just crazy to me that this is another thing, like beyond what they're trying to prove in this email, is just this overriding, this woman is in charge. No question. This email that she's sending to Todd and to Ange and to Justin and to Alex, like she's like, here's my rewrites and this is what we're doing. It's crazy to me. And she's outright talking about things like music and stuff in how she has changed it. And look how she says that though karaoke was problematic because it's not a sexy interaction. And then here we see her changing the music that was already picked and was already settled. Thank you, Gelf. Blake offered her chicken butt. Exactly. Okay, and let's oh sorry, I'm moving my little arm here. And when you see how she describes what she wants the scene to look at, what are some of the words that she uses? She talks about giving the relationship momentum. All right, how are you going to show that? Wouldn't you expect there to be some physicality there? How else do you show momentum? It talks about the audience being swept up in the what? The roaring rapids with Lily and Ryle, quickly approaching a giant but waterfall, crashing into one another with an energy that is not only inevitable but inescapable, thrilling but dangerous, forbidden excitement. Okay, this is the way she's describing what the scene is supposed to be. Now, what kind of visualization does that give you guys? Don't you expect there to be some displays of affection here? You're talking about roaring rapids and thrilling and dangerous and forbidden, a waterfall. And then when it comes to the scene, she wants him to just talk. We're just going to talk. That doesn't match at all. This scene that she's rewritten to make it more sexy described it in all of this way. And then she's like, oh, just talk to me while we dance. Yes, it is. What a dumb thing to say. Like, what does that even mean? And let's see. Yeah, she describes it as intimate and exposed. And then she goes and sues the guy because he leans in and nuzzles her, and at the end kisses her, puts his face up by her face. When I guess forbidden excitement to her is talking. It's so bizarre. But there's no way that you can look at that email and not say this woman was controlling the movie. You just can't. You just can't. Okay. And it also talks about this other character, or this other scene that she writes, white knuckling, the sexual tension. These are all things that she wrote, and this is the scene. And I'm not going to go through and read it all, but this is a very spicy scene. And this was her changing of the script, and yet she's suing Justin for changing the script to make it more sexy. It's so crazy. Like, how do you do that? And those of you who've seen the movie, this is that awful scene where it like, I just wanted to like pour bleach in my eyes, because she wears her fishnet stockings under her pajama pants. Like, I just wanted to just like, I don't know, that sent me into something I will never forget. It's so gross. But here's this like wildly sexual scene, and you look at the book, and here's what the book is. This is directly from the book. My eyes instantly lock with his. Don't have sex with me, because they start kissing. Okay. And then she's like, no, I don't want to do this. And he says, okay, I will not. He walks around me to his bedroom door. He locks it. He flips off the light, leaving only a lamp on, then takes off his shirt and walks toward me. She asks, what are you doing? He tosses his shirt on a chair, slips off his shoes, and says, we're going to sleep. And then he lifts her dress up over her head, And until she's standing there in her bra and panties, no fishnets. And she says she covers herself, but he doesn't even look twice. And then he puts her in the bed, covers her up, they lay down and go to sleep. So this is the actual scene. And then she made it all this sort of spicy stuff. So like I said, it just comes back to she was doing the very thing that she's accusing him. And you're getting really close into unclean hands territory. And I was not the only one disturbed by the fishnets under the pajamas. It literally set TikTok aflame, and probably other Instagram and YouTube and all the others as well. Like all the people, nobody could accept that she climbed into bed with fishnets under her pajamas, because that is so gross. All that polyester wrapped around your legs. I can't even stand to sleep in pajama bottoms. And she's got pajama bottoms over a stinking fishnet stocking. And oh man, where is my I forgot to load it on here. I have a video of it. Shoot. Of one of the girls. She was it's two girls talking, and they are absolutely hilarious, talking about those fishnets on her. I might look it up in a moment and come back to it. But yeah, that was just a Cassidy side quest. I could not let that go unmentioned that she did that. Okay, and then let's see, what did I miss here? Yeah, they finished this up with, nor was this anything that might remotely approach flirtation. She and Baldoni were working, surrounded by actors and crew, and Baldoni's expression was neutral and not ogling or suggestive. I don't see how anyone could watch that video and say otherwise. Okay, and also in the evidence, it points to number 30. We're not going to talk about this a lot. We know that because we did talk about this a lot already in the Cassidy After Dark episodes, that And was saying more heat, more grown up, more sexy. I mean, we see the word heat here twice, and they can't dispute it. But then they put this in, this is their defense. They're saying that it was broadly acknowledged that making the film PG-13 had proven without a doubt to be what was best for the film and the audience. Okay, when they make a claim, when they dispute something, they have to show evidence. Let's turn to that evidence. This is the evidence. This is an email from Alex Sachs. This is not some big direction from Sony. This does not say, oh, the whole world feels like this is better. This is the way it should have been. No, this is a stupid email from Alex. And she says, here are some notes that went to Blake alongside the green draft. And she says that this is now a PG-13 film through and through. All swearing's been removed. And she says, in her opinion, making this film PG-13 has proven without a doubt to be what's best for the film and the audience. That is not proof of anything. Not only that, people had expressed concern earlier about it being labeled PG-13, and one of the reasons that they wanted it to be rated R was they didn't want young people coming to watch it and not being prepared for what kind of content was going to be in there. That's a very good reason for keeping it at R. You don't want kids coming in and watching domestic violence. But yeah, well, Alex said it, so it must be true, right? So stupid. Okay, yeah, this is just going through, like, we went through the video already, but this is going back to that 56.1 statement where it describes her dressed in this oversized fleece. It describes the situation. It describes his face. And that's the evidence that they provide. And they just dispute it. They say it's incomplete and misleading, that he pressured her to expose the partially unzipped onesie she was wearing underneath. Okay, did he unzip it? Why was it unzipped? Why was it unzipped so far that it revealed her lace bra? Nobody made her do that. That was her choice. Why are you putting this in the lawsuit? Like somebody made her do that. That's ridiculous. He said pretty hot. We saw him say that. He said it before she took her coat off. So she was not on display. So any feelings of feeling on display are imagined and probably have more to do with him pointing out there was something in her teeth. And then here's the comment that Jenny Slate says, now we watched that scene. There was not some big blow up. And he did not just roll his eyes, say that. And look, she outright says, before walking away in a huff. Did we see that man walk away at any point? Was he in a huff? Or did he listen to her, do a slight shrug? You could see he was a little uncomfortable. He took a sip of his drink. He did not walk away. He did not get huffy. The three of them stayed there and continued to have a conversation with smiles and laughs, and everything looked friendly. So this is kind of ridiculous that this is even here. And I really, really hope the judge does his job and goes through all of this evidence as he's looking at this. Because historically in this case, he did not. Wayfarer would say this is how something was, and Mike Gottlieb would say, no, this is how it was. And without going back and checking how it actually was, he would side with Mike Gottlieb. And we saw him do this. We saw him, Michael Gottlieb had said something incorrect. And then there was a hearing that the judge had presided over, and it was said that Friedman was representing Jed Wallace. But because Michael said he wasn't, the judge ruled accordingly, forgetting the fact that he'd presided over a hearing where Friedman said so. And another time, he had written something in an order, his own order that he wrote, that he had made a decision on. Wayfarer said, no, it was this. And Michael Gottlieb said, no, it was that. And without going back and checking his own words on an order, he agreed with Michael Gottlieb, and it was wrong. So I really, really, really hope that he's doing what he's supposed to do and going through all this evidence and looking at it and not just going by what Michael Gottlieb said. Okay, and now we get back to the summary judgment motion, and they say, even if you go to a routine office setting, because we've seen how many cases have we gone through now that were routine office settings, that this conduct is not actionable. It talks about a high school teacher's claims that her male supervisor occasionally commented on her physical appearance. And this guy even had a bet going about when she would engage in sexually explicit conversation. And in that case, it was insufficient. And it was determined, and it even went up to the Second Circuit. It just didn't hold water. Another case let me see what I've got about that case. Yeah, so this one, she claims that she was harassed by the principal over a period of 7 years. But if we go through, these are very strange allegations indeed. So in 1999, he said that she looked good and fit, and 2 times. And one of those times, he crooked his finger to call her over to talk to him. then the vice president told her that her coworkers were taking bets on places and times that there would be a sexual conversation. Now, didn't you expect when you saw in the claim that it was going to be him trying to get people to take bets or him taking bets? No, it was the vice president taking bets. And he said Redmond was present at the time of the conversation. She wasn't present. Someone told her this and said he was present. And that's supposed to be a claim. Okay. Then look at this. So she arrives in the spring of, look at how 5 years later, she's late for a faculty meeting. He folded up the meeting agenda and threw it at her. All right, that's not nice, but harassment. Then he falsely told the assistant principal that she used the weight room when she hadn't. He approached her in the school library, asked her where she was supposed to be. Sounds like she was somewhere she wasn't supposed to be. And he touched the side of her body with his. So he bumped into her. Was it on purpose? Was it accidental? We don't know. The next year, in the spring, she was running with a female coworker, and he hollers out to them, "Keep up the good work, girls." Then in the fall of that year, he says she gained weight over the summer. And then the spring of the next year, he came into her classroom and said something derogatory, but we don't even know what that is. And then she also claimed that he underrated her on her performance, that she was passed up for a promotion that ended up given to a male colleague. And but that male colleague was described as getting along better with the faculty, and also that promotion required a recommendation from the principal and the superintendent. She also didn't have the superintendent's recommendation. And then another time, he admonished her because she was late handing in her lesson plans. But it wasn't just her. There were a few other male colleagues that turned theirs in late, and they all got told to turn them in, and they all got the exact same email reminding them to turn their lesson plans in. That's not harassment. If the men were treated exactly the same as her, that's not discrimination. But she filed for discrimination and retaliation under Title VII. And then this is like California has FEHA, New York has NYHRL, which is New York State's human resources law. And one of the things she said when they asked, "Did you file a complaint at the time?" She says she didn't know how, but at the time, she was serving as grievance chairperson for her union. So she was the one people were supposed to come to find out how to file complaints. And she claims she didn't know how to do it. Then another time, when she got written up, she said she told her union rep that she was written up because he had a thing for her, when in fact there was a legitimate reason for her being written up. She had written this email and described one of her students as being severely intellectually challenged. It was on the screen of her computer, and that student saw it. He reported it to his mother. The mother came to the school and filed a complaint. That's why there was a complaint, not because he had a thing for her. And then she comes and she gives her side of how it all happened or why it all happened. He decides to remove it from her file, so it doesn't even stay on her file. But she still goes and files this complaint anyway. So she files a complaint, an investigation is made. Nobody corroborates her claims. There is zero evidence for her claims. Well, then she goes off the deep end and she has a couple of mental health leaves. She files 2 more complaints, this time with the EEOC. They both get dismissed after they're investigated. Then she goes and files a lawsuit. After resigning, she wasn't fired. She didn't lose her position. She didn't get a pay cut. She resigns. And then she files this lawsuit. And the court grants the motion for summary judgment. They're like, there's no claims here. And she can't accept that. So she appeals it. The Second Circuit, they affirm the summary judgment. They say that the evidence is isolated, infrequent, and mild. It does not meet the federal standard, which is the Title VII standard for severe or pervasive discriminatory harassment, nor did it meet the New York. And that's in a routine office setting. So here's one more. This one, I didn't look up. It has a lot of other things happening with it. And for the sake of time, we're just going to kind of skip. This is another one that it gets decided in the Southern District of New York, and it gets escalated because she appeals to the Second Circuit because she loses. She says that a plaintiff told her clothes were sexy and that her hair was beautiful. He sometimes blew kisses, but he did it to other employees or all the employees. And he sent an inappropriate email once and made sexual jokes, but they determined that it was insufficient. And the Second Circuit agreed. And we're going to just skim through this subpoena as well. Same thing. It's a file clerk that claimed that her supervisor complimented her hair and her eyes, said that she looked good in tight pants, and referred to her as a beep twice. It was considered insufficient. It also went to the Second Circuit, and it failed. Okay. So her complaints, they say they're deficient when you view it in the context, because those were run-of-the-mill offices, but this one, and it refers back to the Friends case. It was creative writing, determining a sex scene for a movie, for film. That's a completely different situation. And they said it would be one thing if this was 2 insurance agents or executives reviewing figures on a spreadsheet, and out of nowhere Baldoni alluded to his marital or sexual experiences or to a prior pornography addiction. But they were discussing these issues in the context of creating intimate scenes and adult themes in the film they were making together. And they point out she had complete control in approving any additions to the script concerning intimacy, as well as access to a female intimacy coordinator. So he made suggestions, and all she had to do was say, I'm not comfortable with that. I'm not doing that. And guess what? Nobody made her do it. And then we go, let's see, these evidence things are things we've seen so many times about the situation. Sorry, excuse me, hold on. Just needed a drink. Yeah, we've looked at those so many other times before, and they are about hiring the intimacy coordinator, her not agreeing to meet, and how that all transpired. And then this is what I said a second ago. I got a little ahead of myself. These are the cases like the Friends case and the Real Housewives case, where because this was TV, because this was creativity and entertainment, and it was known to be raunchy entertainment, both dealt with sexual comments, adult themes, it was very clear that this is different than in office, and none of these claims went through, even though personal sexual relationships were discussed. Things were mentioned on Real Housewives. He talked about one of the women's breast augmentation and the size of them. There were a lot of stuff that I think would offend just about anybody, but because of the setting, all of the claims failed. So, and this one was one of Lyman's cases, the Real Housewives one. So it's going to be really odd indeed if he finds differently for Blake than he did in this. And so that wraps up Section A, which is all about Blake's sexual harassment claims not being able to succeed. I think, again, they did a beautiful, magnificent, superb job of covering every bit of law they could, from the U.S. Supreme Court to the Second Circuit to California law, New York law. They brought in cases very similar to Blake's with issues that have the same standard. They showed the standards of those that can actually survive and the standard of those that cannot survive, did not survive. And I think it becomes at this point just completely clear that Blake does not have a case, that something else was going on here. And it's yeah, I can't wait for this ruling either. I really can't wait. I'm going to look for a second to see where I put that that video of the TikTok girl. It was so funny. Did I not save it? Oh, it was Instagram. Yeah, I've got to edit it real quick. But anyway, I kind of had to not pay attention to what was going on in chat while I was going through that, because look, did it go to 2 hours again? These keep coming out way too long. But so I don't know if I missed any important questions or comments. So now is you guys' chance to do that. Let me see if this starts at the right spot. Okay, hold on. It's just so funny, these girls. Okay. All right, let me save it. Sorry to leave you guys hanging. I hope it's worth it for you. All right. Here we go.
I did watch It Ends With Us.
Did read this thing where Blake decided the music and the wardrobe. And I will say the two things that didn't make sense in the movie were the music and the wardrobe.
The part that really just got me is like Blake and Justin are like making out in his room or whatever, and then she's like, "Can I borrow a pair of pajamas?" And she's wearing like this. First of all, the original outfit was insane. She had this dress on with like fishnet tights on, then these like knee-high, like skin-tight rhinestone boots. When she got to the party, she's wearing that stupid camo jacket that was so out of place with this nice outfit. I was like, girl, what's happening? And then so she goes to put the pajamas on, and she doesn't take off the fishnets. So he just puts these pajama pants on top of fishnets. Who's going to bed with fishnets on? unless you are drunk on New Year's Eve.
I was literally like, that shit is so unrelatable. I wouldn't even put them on in the first place.
That.
Unless I was getting paid for a show that required fishnets.
Exactly. Unless it's Halloween or I'm getting paid. Oh,
Everyone was great, really, except Blake. She just wasn't right for it.
There. I hope that was worth it. Did you guys like that as much as I did? Okay, so wait. I am so far behind, guys. So Ryan's getting sued and what? Roses Wild, you guys tell me about this. What the heck is going on and where do I find this? Roses Wild says, Cassidy, what do you think about creators being named in filings for helping Wayfarer with smear campaign again? Again? What? No, I don't know about this. And do you think they should sue Blake? Where is this at, guys? I know nothing of it. So I gotta look two things up. Ryan getting sued. There's not a deadline. This can even like go into the trial. I think he'll probably try to clean it up before the trial, but he's got more time since it was postponed to May. And but yeah, this doesn't have to be determined before the trial actually starts. So there really isn't a deadline. And somebody calls Michael Gottlieb something, but I missed it. I don't know. Yeah, I don't see the name for Gottlieb, but I would love to see it. So Chris Wildfire asked, this is a good question. Do you think Wayfarer could be in trouble if they prove they didn't investigate the complaints when she had them before filing her lawsuit? Well, here's the thing. There's no formal complaint that we've seen filed, at least not that I've seen. And we have conversations that were had where Blake concluded saying that she didn't want to file a complaint, that it was handled. We also have Jenny Slate saying that she didn't join the lawsuit because she felt like her concerns were addressed and that it had been handled. So unless there's some mystery filing that they've never shown and it's too late to introduce new stuff, I don't think there's anything that they can do to prove that an investigation should have been held and wasn't. So that's my opinion. Always check with someone like Little Girl Attorney. So where did this happen? Without a Crystal Ball was named. Where? I didn't see a new filing. Was there a new filing? Oh, is this the lawsuit? One of Ryan's employees got into a car accident and the person was hurt. That's why Ryan's being sued? Was Zach named too? But I mean, which document though? Is it an actual filing? Oh, in the expert report. So it's not a new filing? Michael Gospel Guy. That's how Lyman was treating him. So wouldn't that be, yeah, isn't that older? There's nothing new unsealed, right? Yeah, I'm still mad our motions didn't get addressed. Oh, thank you so much for gifting memberships. I want to do a game night soon. But I keep, like I said, I've been in Germany more than I've been home for the last couple of months. Here we go. Prickly Pear says, Ryan Reynolds and Blake Lively employee was in a car accident while using their car. It's led to a $5 million lawsuit. The crash happened last year. Interesting. Okay, so there's no new filings. Okay. Okay. So yeah, just the expert report. Okay. Okay, got it. I thought something was getting filed. I'm like, what could possibly be filed right now? The only thing I could think of was the Stephanie Jones part, because they still have some things happening over there. Oh, people are running out of stuff to talk about. Oh, okay. Something that got unsealed, and I don't think anyone really noticed it until recently. Okay. Well, I remember Zach was named a while ago with the Jed Wallace stuff. Colleen is being sued too. Everybody is I love this. Like it's all starting to hit now finally. I did hear of a lawsuit against Kevin Costner. I haven't looked into it. But I remember I saw that one was filed and that he denied it, but I haven't gone and actually looked into it. I'm having a hard enough time keeping up with this. Is that one juicy? Is that one interesting? I was lost in the pile. Yeah. Yes, I screenshot that. I sent her a message on Instagram when I saw that posted. I screenshot it. I was gonna do just mention it at some point in a video because it just, to me, it's just heartbreaking. And I can't help myself. I know a lot of people were hurt by this lawsuit, but I will always say what happened to her was the worst of what anybody else got, because the invasion is just it's just too much. It's too much. These awful, horrible people that have it in for her got to read her most intimate conversations and know absolutely everything about her. There are so many things, like protected things, situations about her health, situations, conversations, and videos with her and her fiance, things that is nobody else's business. And how do you get over that? That's a type of violation. It's so horrible. But yeah, her posts, they just, like, I just felt devastated for her all over again. Oh, really? Donnie says Mandy Magnan has been following the Kevin Costner case and everyone on set is backing Kevin up. What in the world is going on? Ugh, calling him the director. Exactly, Gloria. You can't sit at the Blake Lively cool kids lunch table unless you call Justin the director and nothing else. The Kevin Costner case is from 2022, just now coming in front of a judge. I thought it was new. They're still spying and intercepting messages. They're such idiots. We organically cannot stand you, Blake and Ryan, and everything you've done since this has just made it worse. That's my big question. How has this not been filed in a criminal case yet? This really needs to go criminal, in my opinion. Same here, Donnie, because I don't know any of the details. Donnie says she doesn't know how she feels about the Costner case yet, staying neutral for now. Yeah, I have no idea what the I just know that he was accused and he denied it. No words. Buckle up. Buttercup says no words to describe the kind of violation Jen has endured. Exactly. The tiniest thing is smug Stephanie Jones reading about herself. Yeah, it's just too much. Thank you, Gloria. An actress claims that in a movie he's shooting, she was actually assaulted on camera by another actor. An actress claims that in a movie he's shooting, she was actually by him or another actor. I thought, oh, okay. Well, I guess I gotta start reading that. My goodness, the world has just absolutely gone mad, and everybody's it's just, I don't know. That's what I don't know, Michelle. Is someone answering her phone, or does their number just get put back out? I gave up my phone number, and I'm sure someone else has it now. I don't know. It, yeah, I've got it on my phone. I don't have it on my computer, but I do want to talk about that soon, about what she said, but I don't remember the details. So I wonder if she has an Apple phone. Can she do location tracking and just take her phone back? It's a company phone. The number was hers, but the physical phone itself belongs to Stephanie's company. So she can't take it back. All right. Yeah, that's what I said. That's what I said. And, that danger is not necessarily over. I never wanted to, actually put that out into the universe, but I think we all know that. A July baby says people have taken their lives over that much personal violation. They have. I just want her to stay strong, and that's why I sent her a message, and I know she won't respond because of this lawsuit, but I just wanted her to know that we feel it, that it was horrible, and we support her, and we will not shut up about it, because it needs to be answered for, and it needs to never happen again. Yeah, I've heard that too, Buckle Up Buttercup, that people think that they want the judge to dismiss it so she can blame the court, because she's not going to make it in trial. She's just not. So if she says that oh, it's all because of this, and then there will always be people who will always believe that. Yeah, Christina, it will never be over. I agree. Aw, you sent her a message too. Yeah, I wanted to know people care. I didn't even know who she was when this all started, but of everybody injured, I feel like her injury was the worst. Yeah. Buckle Up Buttercup says Justin's owed $1 billion, in my opinion, for stealing his future with lies. Because there will always be people who believe that he did this. Yeah, Ryan will never stop. No, those kind of people, they won't. It's sickening. Well, guys, thank you so much for hanging out with me tonight. We've been on here almost 2.5 hours, so I better end it now, or nobody's gonna watch it later when they see how long it is. But we got through that part about the sexual harassment, and we'll be moving on to the retaliation soon. And thank you guys so much for being here with me, and Christina for your mad modding skills. Thank you, Ricardo, for being a member for so long. Thank you, Gelf. And I love anytime anybody says chicken butt. Thank you, CM. Is it CM Baby? That's what I want to call you, for gifting memberships. And thank you, Gloria, for your super chat. Thank you all. Have a wonderful, wonderful Friday, rest of your Friday night, and wonderful weekend. It is Friday, isn't it? I hope so. Anyway, I will talk to you all very soon. Let's hope more consequences keep hitting the Reynolds.